So in Texas, if you have a contested divorce, if you haven't already agreed on everything up front, you're going to go to a mediation. Mediation is required in all cases. You're never going to see the inside of a courtroom until you've tried to settle your case, unless they've already agreed on things, and generally they don't have any kids. Kids issues generally require a mediated settlement agreement just because the judge is going to want to see certain things in your divorce decree that you may not understand need to happen a certain way. And if you have a out-of-the-box agreement with regard to your kids, you want to make sure that you have documented that in a mediated settlement agreement. So some of the typical things that are included in your mediated settlement agreement, if you have kids, you're going to have provisions that talk about who's going to have primary custody, where the kid's going to live, what kind of visitation schedule are we going to have. You're also going to have a geographic restriction. So we want to make sure that both parents get to see their kids. So if the kids are living with you, you can't pick up and move to Alaska and prevent their other parent from seeing them or make it a lot more difficult. So the courts are going to want to see a geographic restriction that says, I've got to live in a certain area. Typically, that's going to be the county in which you live in and maybe the surrounding counties. It can be more custom than that, but typically you're going to see county that you live in, surrounding counties. That's going to make sure that both parents get reasonable access to the children. You're also going to have a provision that deals with support. Now, some people will agree that no support needs to be paid. That's pretty rare. It's not common. It's not something that you have to agree to. Anytime that there are children in a divorce, a court is going to want to make sure that those kids are taken care of, and they're going to order some child support to be paid. Doesn't matter if you both have equal time with the kids. It doesn't matter if you both make equal amounts. A judge is going to say that somebody's going to pay child support. Now, you can agree that that doesn't have to happen. If you both make about the same amount of money and want to just say, well, we'll equally support the kids, you can do that, but that's got to be in a mediated settlement agreement. In Texas, child support is figured out by a calculator. It's a pretty straightforward guideline in which we're going to look at the parent's net income after taxes, and then we're going to take a percentage of that income depending on the number of kids you have. So if you have one kid, it's 20%. If you have two kids, it's 25%. 3 kids is 30%, up to 40%. And that is a straightforward calculation. Some other clauses that are going to be in your settlement agreement are going to be provisions that deal with division of your assets and liabilities. You're going to have a provision that generally says, how are we going to handle taxes in the year that you get divorced? Sometimes in your divorce, if you are selling a house that you both own together, you are going to have provisions in there about the process for the sale of your house, how those proceeds are going to be divided, who's going to pay for any repairs that need to happen on the house before the house gets sold. There can be a multitude of different clauses in your settlement agreement depending on your situation. You may have heard terms like alimony or spousal support. Texas doesn't have alimony. If you've heard that term, it's from another state. We have something called spousal maintenance. There's 2 different types of spousal maintenance. One is during the divorce, while you're going through the divorce. Maybe you're a stay-at-home spouse and you don't have any income. So while the divorce is going on, you want to make sure that you have access to funds to live on, to make sure that you can support your kids, you can pay the bills. During the divorce process, you're going to have an agreement. It's called a temporary orders agreement. And within that agreement, sometimes your spouse, if they are the one that's making the money, is going to pay you money so that you can pay your bills. Sometimes, instead, they'll just pay the bills. But that is temporary spousal support in a divorce in Texas. We want to make sure that both parties have equal access to funds to support their lifestyle. Just because one party works and the other one doesn't mean that you're cut off. Now, at the end of your divorce, you may be entitled to ongoing spousal maintenance. There's some really, really particular requirements for this. Not everybody gets it. You have to have either been married for at least 10 years, or you were the victim of domestic violence, or you are disabled in some way. And the key thing with ongoing spousal maintenance is that you have to establish either to your spouse and they have to agree, or you have to establish to a judge that you need that money, that you can't support yourself on the income that you could make. So even if you haven't worked, you may have to get a job. You may have to show that you can't work, or you may have to show, well, I can work, but I can only make a little bit of money. It's not going to be enough to support me. You have to establish that that's the case, that your spouse, your soon-to-be ex-spouse, can pay that. Also, this is the kicker. This is where a lot of people lose out on spousal support, is that the judge is going to look at, well, what other assets do you have? They're going to look at, do you have a house? Is there retirement? Are there investment accounts? And if you have any sort of assets at all that you could use to support yourself, it's going to be really difficult for a judge to award you spousal support or spousal maintenance. What we recommend to people is, if that's something you want and you believe you need, your best route to getting spousal maintenance is through negotiation and settlement. Under the law, gender has no influence on spousal support at all. Either spouse, husband or wife, could request spousal maintenance under the law. Typically, honestly, I would say that it would be very unusual for a man to get spousal support. I think that's unfortunately just the world that we live in, and there's probably a bias in the court system against men asking for spousal support. But in Texas, spousal support is rarely granted to either spouse. It is a very high bar to overcome. Our judges, unfortunately, are just stingy in that way. They have really looked at the law and determined that you really have to be in dire straits for spousal support, spousal maintenance to be granted. And it's just a really difficult thing to get from a judge. Once you have your agreement finalized in a mediation, then the next step is to have that documented in a final decree of divorce. Now, your mediated settlement agreement may be a few pages, maybe 10 pages maximum, but your decree is going to be like 50 pages. It's a long document. And the reason for that is that a lot of detail is included in your final decree to make it enforceable, so that you get what you're entitled to, your ex-spouse gets what they're entitled to, and if you need to, you can go back to court and say, this is what they owe me, this is what they were supposed to do, and they didn't do it, and please make them do it. So there has to be a lot of legal language, a lot of detail in your final decree. So it's a pretty long document. Once that decree is prepared, everybody's reviewed it, signed off on it, then you have to get the judge to sign it. And there's a few different ways that this happens depending on the court that you're in. So the typical way is that you would go into court and in person and ask the judge to sign your decree. There's a process where your lawyer will ask you questions to do what we call prove up the decree. Essentially, you're just asking questions that have legal requirements that the judge needs to hear to make sure that they have jurisdiction, to make sure that that the proper things that they want to see included in your order, especially with regard to kids, are included. And then it's just a process where they sign off on the decree. These days, after COVID, most people will do something a little different. They don't have to show up in person. They sign an affidavit testifying to a few specific questions, answering a few specific questions that the judge wants to hear. That affidavit gets filed with the court along with your decree, and the judge signs it and you never see the inside of a courtroom. Some places will do it by Zoom, where you appear in front of the judge by Zoom, answer some questions, and then the judge signs off on your decree. The final process after you've had an agreement is usually pretty simple. If you have any questions about divorce settlements, please reach out to us at DeFord Law Firm. We'd love to help.